Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. This is time set for oral argument in our case number CV18-0779, Speaks versus Lyft. Each side is allocated 20 minutes for argument today. If appellant wishes to reserve a portion of that time, you may do so, but you need to keep track of your own time at the podium clock. Out of respect for counsel, would ask that everyone in attendance make sure their cell phones are off so our proceedings are not interrupted and we can avoid embarrassment. We have reviewed the briefs. We've conferenced the case. We're familiar with the record. We'd ask that you keep that in mind as you present oral argument. Proceedings are being recorded, and so would ask that as you approach the podium, you start by telling us your name and the party that you represent. With that, Mr. Reynolds, you may proceed.
Good morning to the panel, and may it please the court. Scott Reynolds on behalf of appellant Derek Speaks. Your Honor, since you have already indicated that you're fully familiar with the file, I will get right into it. Our position on this appeal is based on the fact that we believe the commissioner in this case did not take into account evidence that was before her and also applied a standard under the Webb case, a liberal standard, which basically drove a Mack truck right through Rule 60B1 and B1 and B6. And based on her view of the liberal standard in the Webb case, we believe she misapplied the law and vacated the judgment that she had previously entered against the garnishee in this case.
Mr. Reynolds, can I ask you a factual question? In reading through the record, if Lyft had honored the original writ, how much money would they have garnished during the period from that point in time until the Rule 60 motion was?
Well, according to their affidavit, which we don't have any way of knowing, Your Honor, realistically, because it wasn't put in place, so we don't know, other than the affidavit that was provided by their...
Well, certainly the trial court could have considered that affidavit, correct?
Yes, they could have.
All right, and they can consider that affidavit in making equity argument under B6, right?
Sure they could, Your Honor. And
so what was, and the affidavit said how much money was how much money did the judgment debtor have to
the judgment debtor, according to that affidavit, had earned $1,553.
And so how much money of that could possibly have Lyft garnished on behalf of your client?
Yeah, that would have been...
negligible?
Yes, Your Honor.
And so in weighing the equities involved in this case, you have, obviously your client was injured because they didn't get pennies. And so we should then punish Lyft and award a judgment of, what was it, $20,000?
$20,000, Your Honor, yes.
And you find that equitable?
Yes, Your Honor, and I believe that if you're going to do business in our state, then you need to comply with the laws. Clearly the legislature sought to put in place a statute that says, look, if you're a garnishee and you have been provided with a writ, we're going to give you a second chance. We're going to require the judgment creditor to go forward, get an order to show cause. But if you don't show up there, if you ignore that one as well, then you're going to be subject to the full amount of the judgment. And that's a legislative decision. That's not mine, that's not the court's, that's what the legislature says. That's what happens when you ignore two formal legal processes in our state. You're going to do business...
But the rule, sorry to interrupt, but the rule does specifically say that in setting aside a default, or on a motion to set aside a default judgment, you can consider the equities involved, correct?
Your Honor, I think that under, well, first of all, the court found,
yes
as I understand it.
Yes or no? The trial judge can consider the equities involved.
Well, Your Honor, I view it as extraordinary circumstances or, versus.
20,000 versus pennies is not extraordinary?
Your Honor, I guess you could say that about any default that's entered in our state. That's what the statute says, and that's a legislative decision. I mean, otherwise, you have no way to make a garnishee comply. I mean, there'd be no downside to them if they just didn't comply. So that's the penalty.
You got your attorney's fees.
Yes, we did.
So to the extent that you had to litigate this and keep forcing Lyft to come into court, your client was reimbursed for their attorney's fees?
Yes, as far as up to the point where there was a motion for reconsideration, yes, the trial court did award us our fees.
Okay. So why isn't that an adequate remedy?
Your Honor, it's not an adequate remedy only because in the way that the court did not take into account the evidence that was before her, and that's our concern here, and that's why we're here. If the court's ruling is allowed to stand, then any garnishee will be able to come into court and get any judgment against it overturned. I mean, it's as simple as that. This is an issue of, this wasn't a clerical error. This was an issue where they got the order to show cause. The person there in charge said she got it, but she said she was too busy to read it. That's not excusable neglect. That's carelessness. That's neglect.
Counsel, let me ask you, typically we review an order granting a motion to set aside a default judgment for abuse of discretion. Do I hear you as arguing an error of law instead? Or are you arguing that discretion was abused?
Your Honor, there's a combination of a couple of things here. We have the garnishment statute, we have Rule 60, and then we have the web standard, that we believe was improperly applied here.
And I understand your reference to the garnishment statute, and if that statute didn't exist, we wouldn't be here. But I read your brief as challenging the application of a procedural rule on specific facts, and I want to make sure I'm understanding your argument correctly. To me, that suggests that we're looking for whether the trial court abused her discretion or not that there was an error of law. But it's your argument, and I want to understand it correctly.
Well, Your Honor, I think there's kind of a combination of both here, and I think under either one, even if it's an abuse of discretion, the court was clearly erroneous in her decision because she didn't take into account evidence that was before her. And specifically, I would like to point out to the court, paragraph 8 of the Douglas affidavit clearly states that she received the order to show cause and she was just too busy to read it. That's not excusable neglect. That's carelessness. That's just ignoring your responsibilities. When you then read...
Counsel, hold on. Let's say for the sake of argument, the sake of further discussion, that we are in total agreement with you that there is not excusable neglect in this case, and the court was just dead wrong on making that finding. Then aren't we right back to the first questions I were asking you about the equity argument?
Yes, Your Honor, and I believe that...
And is that not also, as Judge Thumma pointed out, an abuse of discretion standard we review that?
Yes, it is, Your Honor. You're right about that. But to go on a little bit about that as well, as far as weighing the equities, I mean, when you are talking about B6, 60B6, and you look at the Webb opinion, which they went on and talked about, what is it you're looking at under B6? What circumstances come up? You can see what happened in that case, how the guy he'd just come out of the hospital from a 7-week stay, he had mental issues, he was in a custody battle with his wife, he didn't understand the proceedings, all those things were going on. And the court said, taking all those factors into account, that you get to the equity part of it. Here, Lyft, they're a sophisticated garnishee. This isn't mom and pop auto body shop down the street here, maybe gets one of these once in a blue moon and doesn't really know what to do with it. They're sophisticated. They talked about how many garnishments they've done. That's different. The facts are different there. So I don't think you even get to the equities here when you're talking about a sophisticated garnishee, someone who knows and should know how to do these.
So as a matter of law, B6 that wouldn't apply to a sophisticated company like.
I'm not saying not in any circumstance, Your Honor, not at all. I think there could be situations, I even laid some of that, say there was a fire, or say the person in charge, is having a baby. I mean, there are other things that could come up which might affect
for
that.
B1, for excusable neglect. I'm talking now about equity.
Yeah, equity, that's what I'm talking
Okay.
about. A sprinkler system goes off and ruins all the computer equipment, so they have no way to, and the papers are all ruined. I mean, there are circumstances where that can come up, but B6 should be left for very extreme circumstances. It should be the outer limit of what we're talking about here, not a sophisticated garnishee who says, I'm just not going to get to this because I was served with it and didn't read it.
Don't sophisticated parties make mistakes from time to time?
Sure, Your Honor, I have no issue with, sophisticated parties making mistakes, but this isn't a mistake. She says she got it. She just couldn't bother to read it. That's not a mistake. All right? Yeah, it's carelessness. It's just ignoring her responsibilities. And that's not something I think our law should be supporting. We should say to them, look, you got to do your job. Otherwise, things are going to happen.
Well, and I understand the point, but again, if we're in abuse of discretion standard, there's broad discretion, particularly under 60B6, which is kind of the miscellaneous other of sort of odd lot issues for setting aside judgments. And how does your argument square with the general thought broadly that disputes should be decided on the merits?
Well, Your Honor, I agree with that only to the extent of if there truly is excusable neglect, and you show that under the rule, then you get there. Then you get to that point. But if not, then you don't get it. That's the law, and we should be following the law and applying it. In any event, I did want to point out the court in her ruling on page 2, and it's under the discussion, it's in paragraph 2, and particularly she says, the mistakes were made by April Armstrong, a temporary employee who failed to process the wage garnishment paperwork in a timely fashion. That is the only line she says as far as finding excusable neglect, and then she throws in B6 at the very end. It doesn't really explain why, just that it applies as well. There's no discussion of what the injustice or extraordinary circumstance is. But in any event, that sentence is just wrong. It's absolutely wrong. First of all, the affidavit of Ms. Douglas states that she didn't timely process it. She said that the temporary employee didn't get the original writ. Just didn't get it. And then there was no discussion of, it's this unexplained issue of, well, what happened to it? Nobody knows. Nobody said anything. There's no discussion of it. And I think I've cited cases that talk about that. And she even goes on to say that that was due to confusion over the change in process. I cited you the Dow case that clearly said confusion, office confusion doesn't work. It's not excusable neglect. Might be neglect, might be carelessness, but it's not excusable neglect. Then we go on, and this is to me the biggest thing about this case, is that sentence that I read you where she said she didn't say, the commissioner didn't say anything about and discuss the fact that they were served with the order show cause, but then didn't respond to it, just ignored it.
Does the extraordinary circumstances test under B6, it seems like we're kind of conflating excusable neglect and B6, but carving out just the B6 analysis, if we were to engage in that, can there be extraordinary circumstances solely based on equities, solely based on the inequity of the relief at issue?
Good question, Your Honor. I think that in this case, if you're always going to have in a garnishment situation, a garnishee is always going to be able to say, oh, there's inequities, because when we garnished, it would only be this amount versus the full judgment amount. Right. It's going to be every single case. the judgment creditor could never win that argument, ever. Because if you were going to say, well,
Well,
it's
I guess the
inequitable.
language in B6 is extraordinary. So what I'm asking is sort of the other end of that. Is it the case that it can never be extraordinary because there's always an inequity, or is there a point at which the lack of equity can reach extraordinary circumstances wholly apart from any
Yes,
argument on
and I
excusable
think I
neglect?
discussed that a little bit earlier, Your Honor. I think in cases where, like I said, where there might be a fire or there's a flood in the office.
All of that are, but that's all just factual circumstances that, again, I think would more specifically go to excusable neglect. Here, do the extraordinary circumstances have to contemplate some scenario like that? Or can there, as a matter of law, be extraordinary circumstances solely based on the amount of inequity? Is there a point at which there can be such a lack of equitable?
I believe you have to have circumstances.
Additional.
Yes.
There needs to be something else.
Yes, exactly.
Okay.
I mean, otherwise we're going to run into this, well, if that's just the test.
What's the line?
Yeah, it's just a matter of money, it's. Then,
Isn't that why it's just an abuse of discretion? We let the trial judge make that call?
yes, but not, yes, in some regards, you're right, Your Honor, but I think when it's clearly erroneous or the facts, the evidence that's clearly there, not subject to any type of interpretation is there, I think, under those circumstances, then, the court still, even under an abuse of discretion standard, can go back and say, hey, you didn't consider these. You didn't consider this fact. And I know there's some case law that talks about, look, if you're going to find under 60B1, under excusable neglect, you don't get to go to 60B6, mutually exclusive. And again, the judge, or the commissioner never really talked about 60B6 or why she thought it was, extraordinary circumstances here. Your Honor, I'm going to reserve a little bit of my time for.
Very well. Thank you, Counsel. Mr. Lynn.
Good morning, Your Honors, and may it please the Court. My name is Trey Lynn, and I represent the appellee Lyft, Inc. The first point I would like to discuss is this issue of the excusable neglect. And I think in the briefing and in the argument, there's been a fundamental misunderstanding of what constitutes excusable neglect on the part of an individual versus an organization. In the case law in Arizona, in the cases we've cited, there's a line of, they're called secretary cases, that deal with what constitutes excusable neglect for an organization. And what those cases have found is that there's no excusable neglect for an organization when it does not have some sort of processes or procedures in place to address legal proceedings, things like garnishments. And the example of that is like the Sachs case, where you have an attorney.
So you think there was an adequate showing in this case that Lyft had a process in place to handle these?
Yes, Your Honor, absolutely.
And how many garnishment claims were processed by Lyft?
So Lyft processed, and this was in the declaration, in 2017, Lyft received and processed about 4,275 garnishment requests.
And how many people were handling these 4,000 plus cases?
So at that time, I don't have the exact numbers of the people in the garnishment department, and it changes, it varies. I can say that at the time when this occurred, there were approximately 4 or 5 employees who were handling those. They had even brought in a temporary employee because of an extraordinarily high volume of garnishments that they were receiving at that time. So they were even bringing on extra staff to address those.
And in handling this extreme volume of writs, they were processing them and they would open them and just let them sit there. And that's part of their process. And that's what happened here.
They would not, no, Your Honor. What they would do is the garnishment would come in, and what Ms. Douglas put in her affidavit, the garnishment would come in, it would be assigned to a certain person within the department, depending on what type of garnishment it was. Some were things like child support, some were things like this, where it was a judgment. And that person would then go through and they would review it. They would implement the garnishment as far as withholding of the wages. To the extent they needed to submit an answer or a response, they would do that. And so the process was not to let them come in and sit. What happened here was there was a temporary employee who would come in
To handle the large volume?
to handle the additional large volume. And so what happens is they use CT Corp as their statutory agent, so that's how these come in. And they would go to one individual within the department who is then responsible for distributing the garnishments to whoever needed to handle them. And because of the temporary employee who would come on, that person mistakenly sent that garnishment to the wrong person, and it did not get addressed in a timely manner. And so what that was is, like any organization, no matter how many processes you have in place, you still have individual employees who are handling these things. And there's always the chance that one of these individuals makes a mistake like this.
Okay, and so that's your explanation for the first
Yes.
mistake. And then an order to show cause comes in. And I'm assuming that there's a process in place to handle an order to show cause because that's a more serious claim.
Well, there is in theory. The fact is that
In theory or in practice?
Well, in practice, yes, there is one. What I'm saying is, in this case, what happened was the order to show cause came in. Ms. Douglas was the one responsible for handling that particular issue. At the time, she had received an extraordinarily large volume of garnishments that she was going through, and so it was because of that she didn't see the order to show cause in time to appropriately respond. And again, that is a mistake on her part. That shouldn't happen, and that's why I say in theory that type of thing should not happen. But in this case, it did. And the fact is that Lyft as an organization was not careless in its handling of garnishments. It employs a full staff to deal with garnishments. It has the processes in place to make sure that they're handled. And like I said, in that year, over 4,000 garnishments are handled without incident. And anytime there's an office
Without incident?
without any serious incident, like in this case, of this type of default judgment. And so, anytime there's an office, a legal office, a large company like Lyft, there is the chance that a paper gets misplaced or misfiled or gets buried with some other work that's going on. That's what the case law recognizes happens. You have the cases that we've cited, such as Addison versus Cienega, where an attorney just thinks that he has docketed something, but he hasn't. He's just forgotten. You have many of these secretary cases that we've cited where because a support staff is too busy, they miss something. These things happen, and that's what the law recognizes. The law recognizes that mistakes are going to happen. Human beings are imperfect. We're going to drop the ball here and there. And that's what happened in this case. And part of the reason we have this two-step process, but the mistake happened because the first part, it mistakenly went to the wrong person, and then you have the second part where Ms. Douglas was not able to process it. So an unfortunate circumstance, and certainly one that Lyft does not want to happen and wants to make sure it is complying with these laws. But it happened here, and the case law supports this, that at an organizational level, as long as the company can show that it has these processes in place, and then it was just a rank and file type employee who made a mistake or missed something, then that's sufficient to constitute excusable neglect. And that's especially true in the case of a garnishee. And we talked a little bit about the Webb case and its predecessor cases. This standard was established in 1922 by the Gutierrez case at the Arizona Supreme Court. And what the court held is that when you're dealing with a default judgment against a garnishee, the court should be more liberal in vacating that judgment because the garnishee is an innocent third party. The garnishee has done nothing wrong to harm the judgment debtor. There are no allegations or accusations made against the garnishee. It's purely this innocent third party who's brought in as a part of the collection process. And so, first, Arizona courts have recognized that there's a policy favoring resolution of cases on their merits. and that's to all cases. And then on top of that, you have something even more so when there's an innocent third party who's brought into the proceedings, that there should be more liberality applied there. The Arizona legislature did not abrogate that standard when it amended the garnishment statutes to require an order to show cause hearing. There's nothing in the legislative history, there's nothing in the statute that would do that, and no cases have overruled Webb or its
If we
predecessor.
disagree with you on the excusable neglect, do you still lose?
If you disagree on the excusable neglect, no, Your Honor. And I was going to come to that. Your question earlier was how much money had actually been garnished, and it
Would have
have been, and it was $0 because of the exempt amounts and the low earnings of this particular employee. If the default judgment had been vacated right after it was entered, which is when Lyft contacted the creditors' counsel, they would have been in the exact same place as if it got into place. So even under 12b-6, those equitable considerations, the garnishee or the judgment creditor would have been in the exact same position. So under that standard, we would also prevail just on the equitable considerations.
So let me ask you, we know what happened in this case and what didn't happen in this case, and I hear your argument at least implicating the thought that Lyft has a good system, it just wasn't followed here, and that's what caused the problem. How do we know that it has a good system?
Well, that's in the declaration of Ms. Douglas, so that's in the record, and she explains what the system is that's in place.
And I understand that, and I'm familiar with that, but what if that system itself was flawed?
If the system itself was flawed, if there were evidence in the record that the system itself was flawed, then that might raise an issue. Here in this case, there's no evidence in the record that the system was flawed or that there was some sort of a fatal problem or that these things were happening regularly. None of that's in the record. So like I said, the declaration establishes, in 1 year they're getting over 4,000 garnishments. I can say right now they're getting more than double that, and they continue to revamp their department and build it up and have the necessary staffing to address these. But again, that as far as the record that's before this court, there's no evidence that Lyft's system was inadequate in any way. And so we do believe that they had a sufficient system in place to address these. And again, on the Webb standard, this is even, it's even more true in this case that it should have been vacated, whether it's under the excusable neglect or the equitable considerations. Because again, here you have an innocent third party. Lyft did nothing to harm the judgment creditor.
Oh, yes, they did. They didn't respond to the writ, which required them to expend attorney's fees to try to get the garnishment in place.
Yes, sir,
you did harm.
So I should clarify. I meant they did nothing to harm them in the underlying action as far as the causes of action that led to this. And as far as the attorney's fee that they did have to incur, we do recognize that there, in the garnishment statutes, there's a statute that allows a judgment creditor to obtain attorney's fees from a garnishee who fails to answer a writ of garnishment. And so that we're not challenging. We recognize if Lyft didn't answer and they had to apply for the order to show cause, they had to show up at the hearing, Lyft should be on the hook for those fees. We don't dispute that at all.
Well, what's the cross appeal then for?
So the cross appeal has to deal with the fees that were incurred in opposing the motion to vacate the default judgment. Because we do recognize the statute allows them to recover fees they incurred in obtaining the default judgment against Lyft. That's in the statutory language. There's nothing in the garnishment statutes or any other statutes that allows a party to recover attorney's fees that it incurs when it's opposing a motion that it ultimately loses. So in this situation, the day after the order to show cause hearing, Lyft reached out to opposing counsel and tried to resolve it, explain the situation, explain that the garnishment was going to be put into effect right away, and that no wages would have been garnished in the first place, tried to resolve the issue. But instead was forced to have to go through and file the motion to vacate the default judgment, and was successful on that. And so our position is that the trial court doesn't have that authority to award attorney's fees that the other party incurs in opposing a motion to vacate a default judgment when that motion is successful. And we've not seen anything in the case law, we've not seen any statutes that would support that ability. We understand the trial court has inherent authority to sanction parties for certain conduct. None of that was present here, and in fact, Lyft had a good faith basis to file its motion, and it ultimately won on the motion. And additionally, as far as the evidence, there was a lot of talk about that the trial court ignored relevant evidence, and the trial judge did not. The trial judge properly considered the affidavit that was provided, considered the legal arguments. There's no evidence that she ignored evidence, and there's no support for the argument that Lyft just ignored this garnishment.
Counsel, let me ask you on the fee shifting issue that you just touched upon. If you're right, and that a party opposing a motion to set aside a judgment like was entered here has no right to fee shifting, is that something the court can and should consider in deciding whether to grant the motion to set aside the judgment to begin with? If we're talking about 60B6 where the equities lie, and you've got somebody who, from their perspective, did absolutely the right thing to collect on a judgment, and your client's 0 for 2 in their responses, and then you're saying that the party opposing the motion to set aside doesn't get fees, couldn't that be part of the equities that the court considers and says, wait a minute, this judgment maybe should stand as opposed to being set aside?
I think that the court could potentially, if the court is ruling solely on 12B6 as far as whether it's equitable.
60B6,
Oh,
right?
sorry,
Yeah,
sorry.
no, we're
60B6.
on the same page.
Yes, under 60B6, then in theory the court could consider a wide range of things such as that, such as the attorney's fees that the other side has incurred, whether the parties had the opportunity to avoid filing the motion in the first place.
Whether the parties have the opportunity to shift fees depending on how the motion comes out as well. Wouldn't that be in the mix?
Yes, sure. And I think the court could consider that. And if it was, again, if the court looked at it and said there's no fee shifting, except for the fees that could be awarded for obtaining the default judgment, that in theory could be something that the court could look at. I don't think there's any evidence that the court in this case necessarily considered that or talked about it. It wasn't really raised.
Well, but if you're right on your cross appeal, wouldn't the extension of that argument be a remand for the court to make the call again?
I don't think so, Your Honor, because if it was on, because again, I don't think there's anything in the record that suggests that the court considered that when making its ruling. The primary focus was on the excusable neglect standard and the fact that there is a more liberal standard for vacating default judgments against garnishees. That was the court's primary focus. As opposing counsel stated, there was just very limited talk about 60B6 and the equities, and the judge certainly never, as we put in our brief, there was even on the appellant's side, there were just passing references to attorney's fees. That was never a focal point of the arguments or the judge's consideration.
In sticking with the fees, you're not disputing that if the court can consider fees in resolving a 60B6 motion, was there any argument that these fees were unreasonable?
Your Honor, that goes to the first part of our argument on the fees, which is Lyft was not provided an adequate opportunity to object to the fee application.
Well, but you were going to object on the fact that you thought you shouldn't be, you won that motion, so you shouldn't get the fees. But are you telling me that you have an that's my question. Do you have an objection to the reasonableness of the actual fees submitted?
And I don't have an answer for that. I would have to go look at the exact fee application and the amount of time that was requested. As I recall, it did not seem egregious as far as the amount of time, so that most likely would not have been the focal point. There might have been a couple of time entries that we would have raised. But as far as the total amount of fees, I don't believe that would have been a focal point of our objection. It would have just been the issue of whether they could be awarded fees.
The legal issue of whether they can be awarded fees.
Yes. I'd like to reserve the rest of my time for the rebuttal on the cross appeal.
Very well.
Thank you.
Mr. Reynolds.
Just a couple of items. Judge Newman, I think you had asked about, was there any evidence that the systems they had in place didn't work? And I think the conduct is clear that it didn't work. I don't know how you can take in an order to show cause and let it sit on your desk for 13 days and not be prioritized in some way. That's a failure of a system right there. And this idea that it has to be some sort of systematic thing or that there has to be prior instances, that's not the law. It happened here. We don't have to go in and depose everybody there and figure out whether or not this has happened in other cases or not. It happened. And they had it was their burden to come in and prove it up. And that's what they came in with, Judge. I do ask the court to please look carefully at the Webb decision. I think you'll find in there very clearly that the whole reason why the court, because when it went up from the Court of Appeals to the Supreme Court, the Court of Appeals basically said, we're not going to apply the liberal standard anymore because we don't see any difference between defaulting garnishees or defendants in the rules. And I think that's a very important point. And the court went on and said, yeah, but they didn't get a chance to be heard on the merits. And that was because at the time they didn't have that second procedure in. So I think it's a very valid and good point that we've had the amendment to the statute, but also rules that come in that talk about judgments and what you have to prove to vacate a judgment. So I think those are important things that, the Gutierrez case from 1922, 10 years after our statehood, just isn't, it's just been eroded in our opinion at this point. And you have other things that are in play as far as, dealing with that. I think you have to think about this. If all that's required is for a garnishee to come in and say, hey, we just couldn't get to it, sorry. Yeah, it's not going to, you're not going to be prejudiced very much because it's a little bit of money that you're out. Judgment creditors are, there's no teeth to the statute then. There's no, you don't have any teeth to it. You're telling judgment creditors, hey, you really don't have, very much to, go on there. And you're also telling garnishees, hey, you know what? You want to do business in our state? Don't worry about it. You want to ignore the laws and not show up for or show cause hearings? Go ahead. You'll get out of it in the end. I think that those are important things that the court should consider in ruling on this under the facts of this particular case. Just one note on the secretary cases. None of this was a secretarial error. And in fact, they mentioned the Addison case, and in that case, the lawyer there was actually starting, what the court said, he was actually starting to respond. He got, pulled away. And we think actually the Hirsch case is closer because that's where the lawyer there in the Hirsch case said, yeah, he knew he was supposed to respond, but he just didn't. And that's exactly what happened here. They had this order to show cause. They knew they had to respond. And Judge Newman, even to talk about more about the processes, they don't even talk about how they do the calendar anything, or is there any way to, in our electronic age, of course there's these processes, but they don't talk about that. And you have to wonder why. Any more questions from the panel?
No, thank you, counsel.
Thank you.
Mr. Lynn, I heard nothing with respect to your cross appeal in the presentation, so I assume that means you'll stand in your briefs, but I wanted to confirm that.
Oh, yes, Your Honor.
Very well. Counsel, thank you for your briefing. We appreciate it. Thank you for your presentation here today. We will take the matter under advisement. We'll issue a written ruling in due course. We stand in recess while the courtroom is set up for our next oral argument. Thank you.